Good afternoon, and thank you very much for joining me today for the first of our 2024 series of Charity Bitesize webinars. The topic for today is updating charity governing documents following the recent implementation of the third phase of the Charities Act 2022 changes, which included new provisions regarding changes to governing documents. So what I'm going to cover today is shown on the slide here. I'm going to talk to you for the next sort of 25 minutes, half an hour, about some of the key changes that have been made and came into effect on the 7th of March. What I won't be doing is giving you an absolutely comprehensive guide to updating anything that you might want to change in governing documents. And I'm also only going to be focusing today on updating the governing documents of charitable trusts, charitable unincorporated associations, charitable companies, and CIOs. I won't be touching on any of the other types of legal forms that have quite different processes. So that's the sort of the breadth of what we've got time for in today's bite-sized webinar. So I'm going to start off with an overview of the changes that have been introduced under the Act, and then I'm going to talk in a bit of detail about the most significant of those changes, which is this wide new statutory power of amendment that applies to all types of unincorporated charities. I'm then going to talk about the new process that's come in for amending the objects of charities, which applies now to companies, CIOs, trusts, and unincorporated associations in the same way. So that change is relevant to everybody, and I'm going to talk you through what has changed and how that's going to work in practice. I'll then touch on other types of regulated alterations. So these are changes for which Charity Commission consent is required, and just tell you some of the differences that still apply between incorporated charities, that's companies and CIOs, and unincorporated charities, so trusts and unincorporated associations. And then we'll finish off with a brief overview of what it is you have to do to make amendments under the new rules. As I said, it won't be thoroughly comprehensive, but it will be an overview of the steps that you need to take and some top tips having looked at the new Charity Commission forms, which are now all on the My Charity Commission portal page. Okay, so to begin with, the changes that have been introduced under the 2022 Act. Well, as you might recall from previous articles or commentary that we've given on this topic, the intention with all of these changes was to simplify the procedure and make your lives easier, make it much simpler for charity trustees and members of charities to make changes to their own governing documents without the complexity that used to apply, in particular, in relation to unincorporated charities. So that new statutory power of amendment for unincorporated charities is a really significant change and dramatically simplifies the process that unincorporated charities need to follow. But there have been other small changes that might seem subtle, but are quite relevant in bringing into line the processes for all of the different legal forms, because one of the goals was to make things much more consistent as far as possible. So for companies there, I've made a note that there is a small change to when it is that you have to apply for consent to amend the objects of a charitable company. And the reason for that change is so that the test, when is consent needed, is the same for unincorporated charities, companies, and CIOs. So it's bringing companies into line with the position that has always been the case for CIOs and reflecting the new position that's now in place for unincorporated charities. So because of those changes to the objects and the new test that applies to all of the legal forms in terms of what the Charity Commission must consider when deciding whether to approve a request to amend objects, I'm going to talk to you in a bit of detail about that new process that applies to everybody when looking to update the purposes of your charity. For CIOs specifically, there's also been another small but significant change, again, with the view of bringing everything more into alignment. So CIOs up until the 7th of March could make changes in the very similar way to charitable companies. However, those amendments, even where no consent was needed from the Charity Commission, would only take effect once registered by the Commission. Now, any of you who are trustees of a CIO and have tried to make changes, administrative minor changes to your governing document, to your constitution, may well have experienced, particularly after the My Charity Commission account portal was launched, you may have experienced some delays in getting those changes registered. And in practice, that can cause some problems, because if you're trying to make a change, which you then need to use to make another decision, and you have to wait for the Commission to file and register that amendment before you can proceed, it can cause problems either in transactions or generally in decision making for charity trustees. And the argument is, where Charity Commission consent isn't needed for the change, then the amendment should be immediately effective. And so that's what's happened with CIOs. It's now been brought into alignment with the position for companies and now the new position for unincorporated charities. Just briefly touching on an important point that is not always commented on, is this extension of the Charity Commission's powers to require public notice to be given. Now, this is a small but important point to bear in mind. The Commission now has the power, whenever you apply for any consent, so any type of regulated alteration to your governing documents, the Commission has the power to either require you to give notice publicly of the request that's been submitted, or the Commission can do it itself if it considers that there is a public interest in making that more widely known. And similarly, after giving consent, the Commission can either require you to give public notice, or it can directly do it itself. Now, it's yet to be seen how the Commission will utilise that new power in practice, but it could make the process a little bit more time-consuming, perhaps more costly and administratively burdensome if it's overutilised. But at the same time, it may be very helpful where you are a stakeholder in a charity, or for people who are stakeholders in charities, to be aware of a proposed change before it is made. And I think the intention, which you'll see in some of the questions that the Commission now asks on its form, is to try to make sure that people who are going to be affected by a change that's been requested are informed and have been properly consulted. So again, we'll have to see how that plays out in practice, but it is a new power that the Commission now has. And the final point I just wanted to touch on is that although the general intention was to make the process far more consistent, and that has been achieved, the Commission does recognise that there are still subtle differences for different types of legal form. And so the new republished CC36 guidance, which is the Charity Commission's guidance on how to amend your governing documents, has been split out. So there is a separate document for unincorporated charities, for companies, and for CIOs. And this means that you can go directly to the guidance that's relevant to the charity that you are trying to amend its governing document. So it's important that you are aware of what type of charity you're a trustee of in order to find the right guidance and follow the process that applies to you. Now, for those of you who've either attended our online trustee training in the past, or perhaps a previous webinar, you might recognise this slide. We've used it previously, and it's just a snapshot of the different legal forms that are available for charities and some of the common types of governing documents that those charities then have. Now, I'm not going to, again, going through this in any detail today, but if you're at all unsure of the legal form of your charity, it may well be something that you would like to seek professional advice to be clear about, because it does make a difference in a lot of different respects, not just around updating governing documents. Now, as I mentioned at the start, I'm only touching today on the process to amend the governing documents of the top 4 listed in that table. I'm not going to touch on the other types at all. Okay, so what is this new statutory power of amendment for unincorporated charities? Well, it's set out in sections 280A and B of the Charities Act 2011, and it replaces 14 previous statutory provisions which have all been repealed. So it significantly simplifies the process. If you attended my webinar a few years ago on updating governing documents, and you are a trustee of a charitable trust or an unincorporated association, you might recall that it was quite a complex process up until the 7th of March. Well, all of that's now gone, and this power is available to all types of unincorporated charities. It is a very wide general power to make any amendments to any provisions of your governing documents by passing the appropriate resolutions. It applies in addition to any express power that you have in your governing documents. So if you have an express power that is quite narrow, you might prefer to use the statutory power if it gives you more scope to make changes that you want to make. It cannot be excluded or modified in your governing documents either, so it is always available, regardless of what your express provision and the express power of amendment says, if you have one. But it cannot be used. There are some limitations. It cannot be used in any way that would result in the removal of charitable status. And as you would expect, there are certain types of changes for which Charity Commission consent is required. So in effect, what's been done here is the process for amending the governing documents of unincorporated charities has been brought into line with the process that already and has always applied for charitable companies and CIOs. It's interlined with it, but not identical, not quite identical. But the overarching point is you can make any changes you like. If they require Charity Commission consent, you can't make those changes, or at least those changes will be ineffective without that consent. But otherwise, if you pass the necessary resolutions, you can make any changes that you would like to make to your governing documents. And that's the position that's always applied to charitable companies and CIOs. So what it has done is introduced a sort of quasi-regulated alterations regime for unincorporated charities. And whilst that terminology isn't used in the legislation, that is the terminology that the Commission has adopted in its guidance, just to keep things simple. So unincorporated charities, companies and CIOs, you can make changes by passing the appropriate resolutions, but there are certain changes for which Charity Commission consent is needed, and these are referred to as regulated alterations. I'm going to come back to that topic of regulated alterations in a moment, so I'll just leave that there for now. In terms of the process, as I said, you just need to pass the appropriate resolution. Well, that varies a little bit depending on whether you're a trust or an unincorporated association. So charitable trusts only have trustees, they don't have a wider membership. So in that case, the resolution must be passed by at least 75% of the charity trustees. That's it. Once you've passed that resolution, the amendment is made. For unincorporated associations, where you have a wider body of members in addition to your charity trustees, you need a simple majority, that's more than half of your charity trustees to approve, and then you need to go to your membership and seek approval from them. If you do that in a general meeting, you need 75% of the members attending and voting at that meeting to approve the change. If you're doing it outside of a meeting, it does have to be unanimous. So in general, for an unincorporated association with a very wide membership, it is going to be best to try and coincide those changes with a scheduled meeting, for example, the AGM. So I mentioned that there's a new process then for amending objects of charities, which applies to all types of legal form. Now, this replaces the old C-Pray scheme and the statutory power that was only available for very small charities where you are unincorporated. So all of that is gone. If you now want to change your charitable purposes and you are a trust or an unincorporated association, you apply to the Charity Commission for consent, and the exact same process applies to you as it does to companies and CIOs. So it's all now completely consistent. For companies and CIOs, the change means that it is slightly more onerous in terms of the considerations that the Commission will apply than it used to be. But for trusts and unincorporated associations, it's significantly simpler because the old C-Pray regime was really quite complex and sometimes difficult to navigate. Now, for charitable companies, I said earlier that there was also been a change in when you need to seek consent. So again, this is to make the process the same for all. Now, previously, any change at all, any amendment that you made to the objects clause in your Articles of Association required consent, even if that change didn't actually substantively alter the purposes for which your charity was established. Well, that's now changed, and the new position is aligned with what's always been the case for CIOs and what is now the case for trusts and unincorporated associations. So the new rule is, if you're making an amendment anywhere in your governing documents, which will alter the purposes for which your charity is established, you need consent. So it's more of a substantive test. Are you making a substantive change to your charitable purposes? Now, that can be difficult, and it might be a bit of a judgment call as to whether or not it's substantive. And my recommendation would be that if in doubt, seek consent, because what you don't want is to assume that what you're doing isn't substantive, go ahead without consent only to find that subsequently the Commission decides that actually you should have sought consent and therefore that amendment was ineffective and you've been acting ultra vires or outside your powers since passing that resolution. So if in doubt, it's always better to seek consent than to rely on the fact that the change is not substantive. So as I said, it's now a consistent approach for all the different legal forms. And there are new provisions that apply in terms of what the Commission must consider when you apply to change your charitable purposes. Those considerations are based on the old CPRE regime that used to apply to trusts and unincorporated associations, but not identical and a bit more simple. And there are just 3 tests that need to be applied. So, looking at those tests, as I said, it's applicable to all, and there are 3 key things to consider. Firstly, when you apply to change your objects, the Commission will have regard to what the original, very original purposes of your charity were at the time it was formed, if those are reasonably ascertainable. They just have to consider what those original purposes were. They then have to have regard to the desirability for the new objects to be as similar as possible, or as is reasonably practicable in the circumstances, with the current objects. So your proposed new changes, the new objects you want to adopt, need to be still quite similar as far as is reasonably practicable with your current objects. And bearing in mind your current objects might already have been changed from the original purposes for which the charity was established. So what the Commission is doing here is just looking at how things have changed over time and making sure that any changes are reasonable and proportionate. And then that 3rd test is one that's a bit more familiar for charitable companies, because it is the test that's always applied there, which is, current social and economic circumstances. It is also a test that used to apply under the CPRE regime. So the Commission will have regard to the desirability for your charity's objects to be appropriate, taking into account prevailing social and economic circumstances. Now, this is quite a change for charitable companies and CIOs, because previously what the Commission looked at is, are the new objects exclusively charitable for the public benefit? Is the decision to make the change rational in the circumstances of the charity? And do the new objects undermine in any way or work against the current object? So that's what they used to look at. And all of that's now gone, and these new tests apply to everyone. So as you can see, it is a slightly more onerous, or just a different emphasis for charitable companies and CIOs, but it is simpler and streamlined across all different legal forms. So the new process, I need to go back, sorry. Clicked ahead too quickly there. So the new process for amending the objects, as I said earlier, it is on the My Charity Commission account portal. So you go into that portal and go through the form for amending your governing documents. Now, the forms are slightly different depending on whether you're an unincorporated charity or a company or a CIO. But I've included on the slide here the key questions that will be asked in respect of all legal forms. And as you'll see here, those questions relate very heavily to the test that the Commission has to apply. So your answers to those questions will be really important. They will be the factors that the Commission will take into account when deciding whether or not to approve your request for consent to amend the objects. So they want to know, why do you think that they are as similar as is reasonable in the charity circumstances? How will they be suitable and effective in light of current social and economic circumstances? So that's those last 2 tests that I just talked about. The Commission's also going to ask questions about what activities the charity intends to carry out to further those new objects. Now that's interesting, because what I think that's doing is bringing into line the process the Commission applies when they first register a new charity and consider the extent to which the proposed objects are charitable. So what they're doing is they're saying, well, look, you've been operating as a charity for the public benefit. You now wish to make a change. We need to satisfy ourselves that that change is still going to mean that you're operating for charitable purposes for the public benefit. And in order for us to assess that, we need to understand what you're doing, who's going to benefit, who will the beneficiaries be, will there be any incidental private benefit or detriment or harm? And these are all the sorts of considerations that apply when a new charity is being registered for the first time. The Commission will also ask what factors the trustees have considered when deciding to make the change. And when you read the explanatory notes under that question, this to me seems to be the main question the Commission will consider when determining whether or not to require public notice to be given. And so looking at the form itself, the Commission asks, have you carried out any consultation at all with beneficiaries, other stakeholders, funders, or the wider public? Do you think that the proposed changes will be controversial? What might the impact be on current beneficiaries? And has there been any identified conflict of interest in the proposal? So those are some of the questions the Commission want you to answer when you're putting in the factors that the trustees have taken into account. And I expect that the answer to that question will be how the Commission determines whether or not to require public notice to be given. You then finally have to explain why the change is needed, and this is satisfying the Commission that you believe it's in the best interest of the charity to change the objects and why. So it's a bit more of a free text box where you can explain your thinking and the rationale for the decision that you've taken. Now, I mentioned the form is slightly different for unincorporated charities. There are some additional questions on the form around whether or not your charity has permanent endowment and whether the change that you're seeking consent for would affect the rights of third parties or need consent from any third parties. Now, the reason for those additional questions is to do with the slight differences in regulated alterations that apply to unincorporated charities versus those that apply to companies and CIOs. So looking at those other regulated alterations, I've set out on the slide here, on one side, those that apply to charitable companies and CIOs. There's not a change there except that change for companies that I already mentioned, which brings the regime in line, which is that it's only if you're altering the substantive purposes that change would require consent. But the same as has always been the case. So alteration to the objects, alteration to the provisions directing what happens to the property of the charity when it's dissolved, and amendments to the governing document that would authorize personal benefits to trustees, members, or persons connected with them. So those are the same. For unincorporated charities, there are 4 additional types of change that would require consent from the Commission. And those are largely to do with third-party rights and permanent endowment. So the first one there is any change, any amendment to the governing document that would alter a restriction that has the result of property being held as permanent endowment. So anything that changes a requirement for you to hold property in perpetuity and not spend the capital, which is sometimes seen in the governing documents of charitable trusts. Also, any amendment that would require the consent of a third party, unless that third party has ceased to exist or died, and any amendment that would affect any third party rights that are directly conferred within that governing document. It's really common, for example, for village hall charities to have a right for members of the local village to attend and vote at meetings, but they might not be members in the sort of constitutional sense, but they would still have rights to vote on changes to the governing document, for example. And if you were looking to make a change that affected those third-party rights that were directly conferred within the governing document, then you would need to seek consent from the Commission. And then the final point there is any amendment that would have the result of giving anybody the power to make a change without needing to go to the Commission. So it's a sort of entrenchment there, if you like. So those are the regulated alteration provisions that apply, and that's why there's a slight difference in the questions that you are asked on the form when you're applying for consent from the Commission. Again, some of those might be difficult to establish. It may be difficult for you when you're looking at the changes you want to make to work out whether or not you are falling into any of those categories of regulated alteration as an unincorporated charity. And again, if in doubt, you may wish to seek some professional advice and support. So broadly speaking, in terms of the process, I would say anything that's regulated or more complex, where you're not entirely sure how to apply the rules, or where you just want to have the certainty that you've provided the Commission with the right sort of information to have the best chance of success at getting the consent you need, you may want to consider seeking professional advice for that application. But the more simple, routine, administrative changes, you should be able to manage those internally. And these new changes should make it far simpler for you to do so. In very broad terms, the process is now really similar for all different legal forms. The starting point is you need to make sure the charity trustees are happy that the proposed amendment is in the best interest of the charity. A simple majority is required for companies, CIOs, and unincorporated associations, and that's because all three have a second tier of consent from the membership. But charitable trusts need a 75% majority approval, and then you don't have members, so there's no other step to take. So that's your starting point. For those types of charities that do have a membership, you do need to seek that resolution from the members. Now, I've called it a special resolution. That is company law terminology, but that's because all of them require this 75% threshold, this higher threshold of consent. So companies are slightly different to CIOs and unincorporated associations. You can get either 75% of the members attending and voting at a general meeting, or you can pass a written special resolution. Again, you only need 75% of the whole membership in that case. Now, the slight difference for companies and unincorporated associations is that 75% within a general meeting only applies if you're seeking the consent within a meeting. If you're trying to get consent of your membership outside a meeting, it does have to be unanimous. So depending on the size of your membership, that may or may not be pragmatic and practical. Now, if you need Charity Commission consent, or indeed consent from any other third parties, you need to obtain that as part of the process. Now, I've put it in this order that you would get the consent first and then apply to the Commission. So those resolutions in that case would be conditional on obtaining Charity Commission consent. That's one way to do it. Alternatively, if you prefer, you could get the charity trustee approval and then apply to the Commission and then go to your members after the fact. Now, in the Commission's guidance for the types of charities that do have a wider membership, they recommend that you seek Commission consent before you take a proposal to your membership. Now, I think that that's entirely up to you. In a lot of cases, you may prefer to go to your members first before you seek Commission approval, particularly if you only hold an AGM once a year and you don't want to have the cost and expense of calling a separate members meeting at some other time. So depending on the timing of when you're looking to make the change, it may suit you to take the amendment to the members before you apply to the Commission for consent. I think the other factor to bear in mind is this point around public notice of requested amendments and the questions you need to answer about consulting with your stakeholders. Now, if you go to the Commission to seek consent for a regulated alteration for which you don't have member approval yet, then you'll have to explain that you haven't actually found out whether or not your members are supportive of the change that you're trying to make. So I think in many cases, actually, this process of getting your members' approval first, consulting with the people that are going to be affected by the change, and then applying to the Commission may well, in practice, be the preferred route. So you go to the Commission for consent when it's needed, and I've been through already the circumstances where regulated alterations apply and therefore Charity Commission consent is needed. Then, once you've been through all of those steps, the amendments are effective. So again, as I said earlier, CIOs have had a change so that they are now effective immediately if you don't need consent, or after all of the consents and all of the resolutions have been passed if you do, unless the resolution itself specifies a later effective date. And that is something you can do. So you could pass a resolution to make a change with effect from some date in the future. And if the resolution says that, then the amendments come into effect on that date in the future, provided that you've got all of the consents that you need for the change. Now, that's everything that I was planning to cover today. I appreciate it's been a bit of a whistle-stop tour through the process and the changes, but hopefully you can see that it's quite simplified compared to what it used to be. And there is this new guidance, which I would encourage you to read through. It's reflecting the Commission's new approach now, which is to have much more simple language in its guidance. So hopefully when you read it through, it should be quite easy to follow and to make sense of. Now, I'm just having a quick look at questions here that you've raised, and there's quite a good question asking for an example of a substantive change and a non-substantive change in the objects. That's a very good question. I think probably the most easy example would be if you had a set of objects that includes the language which a lot of charities have, in particular but not exclusively by, then the language that follows that is not necessary, and it is an example of how you might further your objects. So if you were, say, a charity established for the advancement of education, in particular but not exclusively by delivering courses in a particular subject, and you then wanted to change the means by which you were advancing education, or you wanted to add more clarity around what you're doing, or remove that language following the in particular but not exclusively by, that might not be a substantive change because you're still advancing education. And because the language is in particular but not exclusively by, there are lots of other ways in which you can advance education already. You're not limited to only those means. An example of a substantive change may be broadening the geographical area in which you're operating, for example. So whilst your purposes are still, say, advancement of or a recreational charity, so a village hall charity, for example, you would have the same recreational objects, but if you want to broaden the beneficiary class and broaden the geographical area, then that would be a substantive change because you're changing the scope of the beneficiaries who can benefit from what it is that you do. Hopefully those are helpful illustrations as to when it may be substantive and not. But as I said, if in doubt, always best to seek consent. So that's it. That's us done for today. Thank you so much for attending. I hope you found it useful. You will get a copy of the recording and will be able to review the slides and the content at your leisure in future if you'd like to. We have also written a series of articles on the changes under the Charities Act 2022. So do have a look at our website if you'd like to have a look in more detail. And as I said, I would encourage you to have a look at the Charity Commission guidance, which is far more simple than it used to be and should be fairly easy to follow. Thanks very much for attending. Take care.